What if the right to a lawyer depends on who is allowed to become one? Yesterday, we talked about Powell v. Alabama and the constitutional right to counsel. But today, we're taking a step back to ask a harder question. Who gets access to the profession in the first place? In the 1800s, most American lawyers didn't attend law school. But in the late 19th century, legal education became more formalized. At Harvard Law School, Dean Christopher Langdell introduced the case method, treating law as a scientific discipline built around appellate opinions. Law schools increasingly adopted standardized curricula, written exams, and centralized instruction. In the early 20th century, the American Bar Association began pushing for uniform accreditation standards. By mid-century, graduation from an ABA-accredited law school became the dominant path to bar admission. But that shift narrowed entry. In 1948, the Law School Admission Council introduced the LSAT. It was designed to measure aptitude for legal reasoning. And over time, it became the central admissions metric for law schools across the country. Today, the legal profession remains underrepresented. According to the ABA, Black Americans make up roughly 13% of the US population, but less than 6% of practicing attorneys. Access is not evenly distributed, and that reality has a history. In 1949, Virgil D. Hawkins applied to the University of Florida College of Law. He met the academic qualifications. He was denied solely because he was Black. Hawkins fought for admission for years. The Florida Supreme Court initially ordered his admission, but enforcement stalled, and he never enrolled. Hawkins' case illustrates something important. Formal barriers fall, but structural barriers remained. Quick power check. Law schools control admissions. States control licensing. Bar exams determine who may practice. These systems shape who interprets the Constitution, who argues cases, and who represents whole communities. Standards are not inherently unjust, but standards reflect the priorities of the era in which they are created. And historically, Black access to the legal profession has required litigation, resistance, and extraordinary persistence. Rights matter, but access to the profession determines who gets to wield them. Your voice matters. Use it in 2026.